Everybody, Mike Kennedy, Vermont Bar Council. Today's blog post, if you will, is by video. I was going to do it from my garage. I was feeling nostalgic and thought about doing a series of garage bar videos, harkening back to the early days of the pandemic when that's where I presented from. But there was a lot of work going on outside my condo. So I came to the office and I'm doing the video here. Could easily do a blog post, but actually didn't feel like just reproducing one I've already done. And different people learn in different ways. So sometimes I should incorporate video in case people find that more helpful than reading a blog post. Okay, today's message is a very, very basic one I've delivered often. Regular readers and CLE attenders might say, I've delivered it ad nauseum and I should stop, but I'm not going to, because the goal is not to deliver a message until you know it. The goal is, and this is an old coaching analogy or saying, the goal is to deliver the message until you can't possibly forget it. So that's what I'm doing. First, a little bit of background on, so today's topic is how to avoid disciplinary complaints. And it made me think about just, the importance of the type of system that we have here in Vermont. So, and I will get to how to avoid disciplinary complaints in a moment. But just to recap, 2011, 2012, I'd been the prosecutor for a while, had a full-time deputy. And we, back then, put almost all of our resources into responding to complaints, investigating complaints, dismissing some, prosecuting others. And when you prosecute a disciplinary violation and you get to the point where either a hearing panel, which is our version of a trial court, or the Supreme Court, which has the ultimate authority in Vermont to impose lawyer discipline, when you get to the point where one of those bodies is imposing a sanction, every decision or opinion includes language sort of to the effect that, and don't quote me, but it's essentially the purpose of a sanction is not to punish the lawyer. It's to protect the public, to promote the public's confidence in a self-regulating profession, that we will act to regulate ourselves, and to deter future misconduct. When you think about that from a public protection standpoint, and this is what we thought back then, and it wasn't just us. We drew from conversations going on at the ABA level, some resolutions that had been passed over the years by the ABA House of Delegates, along with reports and commissions that had studied how best to structure an attorney regulation system, what some other states were doing. We realized that, true public protection includes doing more up front, not just responding after a lawyer has violated the rules, but what are we doing to help lawyers not to violate the rules? That's as important when it comes to public protection. I've often used the analogy. It's Smokey Bear in the old Forest Service commercials. We're not just going to come and put the fire out after it starts. We're going to do what we can, raise awareness on how to prevent forest fires. So that's sort of what we're doing here. So not sort of what we're doing here. That's what we are doing here and have been doing for the last almost 15 years now. So in that context, how do I avoid a disciplinary complaint, Mike? I've been clear. To me, the main way is to disabuse clients of unreasonable expectations that they have about the representation. I've reviewed a lot of complaints. Reviewed almost every complaint for around 20 years, was out of the complaint reviewing business for a couple of years and am now back in with the court having reassigned screening to Bar Council. And sure, there are complaints that are going to be filed no matter what. And those are, for example, complaints involving misappropriation of or a failure to account for client funds, lying to a client about the status of their case, which they always figure out in the end, by the way, lying to a judge, communicating with another lawyer's client without that lawyer's permission, switching sides and representing someone who's adverse to a former client. Those will always result in complaints. Those are rare. They don't happen very often. The bulk of our complaints come down to, and so how do I avoid a disciplinary complaint? Well, what do people usually allege? And don't think of it that way. Think of it like this. People make a complaint when things don't go as they expected them to go, when they don't get in the end what they expected you to deliver for them or to them. And I don't blame these people for making complaints, because they access a lawyer, or they access the legal system and process, not having any, they're not trained. They don't know exactly what to expect. Sure, the internet might tell them something, or a friend might have said, yeah, this is how it works. But their expectations are really not necessarily supposed to be reasonable. This is a foreign system. We speak a different language. It's your job as a lawyer to, when you know that they have unreasonable expectations, to clarify what they should expect. And, just stepping back for a second, the example I've often used, and it'll span practice areas, but you'll get the picture, I think. The client who has an injury claim, or a claim for any type of any type of claim that involves money damages. And for whatever reason, they're convinced that the claim is worth, pick a number, $500,000. You know that it's not, that it's maybe worth 75, maybe. But you don't really work hard at disabusing them of their lingering conviction, belief that they're going to get 500,000 in the end. And you get them 100,000, which is more than reasonably could have expected. It's more than that 75. And great. But, later on, they start thinking about, wait a minute. It's like buyer's remorse in a way. I only got 100,000. That case was worth 500,000. I know it was. If my lawyer would have been better, I would have gotten more money. And what do they do when that happens? They make a complaint. And even if it's not a violation, I'll save that for a moment. Again, it spans the practice areas. It could happen in family law. Someone comes to a lawyer to get divorced, and because their sibling or their friend or their coworker got a certain amount of property in their divorce, or got to see the kids a certain amount of time and on such a certain schedule in their divorce, the person who's going through the new divorce, who's seeking your advice, they expect they're going to get the same thing. That's what my friend told me that they got. That's what my sister told me she got. That's what Google says I should get. When that's not how it works at all. That's not what they're going to get. But you kind of let them believe that that's what they're going to get. And they don't in the end get what you let them wrongly believe they would get. How does that manifest itself afterwards? How could this have happened? My lawyer must not have done their job. So it's a complaint. And again, it spans the practice areas. So I think the most important thing we can do then to avoid complaints being filed, and that makes up a huge chunk of our complaints, where, I didn't really get what I wanted, and must be my lawyer's fault. Well, what did you want, is what we ask. Well, that was never going to happen. It's not your lawyer's fault you didn't get that. So I think up front, one of the most important things you can do in the attorney-client relationship is set reasonable expectations about how much it's going to, set reasonable expectations about the result. What are they looking at? It doesn't have to be precise, but a range, and certainly if they are well outside the range and their expectation, correct them. Set reasonable expectations about how long it's going to take. Even if you don't know how long it's going to take, but you realize that they think this is going to be over in a couple months. That's not going to happen. So tell them. Set reasonable expectations about what your bill is going to be, about how often you're going to communicate with them, about what you will do and what you will not be doing. We do get complaints that allege my lawyer never did this. And the lawyer's response is, Mike, why would I have done that? That has nothing to do with what they hired me to do. Yeah, but you knew they wanted that. So why didn't you just tell them you weren't going to do that? Why didn't you make that clear in the representation agreement? All these things we can do to clarify what's going on and what they should and should not expect go a long way towards preventing complaints to be filed. They may not be happy to hear it, but in the end, they understand and they don't make complaints because they get exactly or roughly close to what you told them they could expect from the process, even if what they get from the process is not what they want to get or would have hoped to get. As long as it's what you tell them or close to what you tell them they're going to get, they're far less likely to file complaints. So one question I get, well, Mike, do you think it's a violation then when I don't clarify to my client that their expectations are unreasonable? And I don't know if it's a violation. I used to suggest, no, it's not. I think I just did a couple minutes ago. Is it a violation to get them 100,000 when really all they could reasonably expect was 75? Is it a violation that you got them 100, even though they wanted 500? Probably not. But let's look at a couple rules to see how it might be a violation. And before we do that, take whether it's a violation out of it. Like I said, it's going to result in a complaint. And having a complaint filed against you is not fun. Not fun at all. The process can take a long time to resolve the complaint, so it's constantly hanging over you. We try to do the best we can, but sometimes it takes a while. You might have to notify your carrier. Your rates might go up. You might get sued by the same client. That's not fun. The same client might decide, you know what? You were so bad I had to file a complaint against you that I'm not going to pay you. It's just not fun to have happen. So whether or not it's a violation, it's still important to not have to, so that you don't go through the process to disabuse clients of those unreasonable expectations. Could it be a violation? Maybe. Let's take a look at, so rule 1.4, I want to make sure I get it right. It sets out our duty of communication, the duty of communication that we owe to clients. And what paragraph B says is that a lawyer shall explain a matter to the extent reasonably necessary for the client to make informed decisions about the representation. Here's what I wrote in a blog post I did a couple months ago. Arguably, a client with obviously unreasonable expectations cannot make informed decisions about the representation. And I stand by that. For instance, that client, can they really make an informed decision to settle for 100 grand when you've not corrected their unreasonable expectation that the case is worth 500 grand? Arguably they can't. So, maybe it is a violation. There's another rule. It's rule 2.1. It's called advisor. I don't think I've ever seen it invoked by a disciplinary prosecutor here or anywhere else. Maybe it has, but I don't recall reading a disciplinary opinion that's based in a violation of the rule. But what it says is this: in representing a client, a lawyer shall exercise independent professional judgment and render candid legal advice. Candid legal advice. That's your job. You shall render candid legal advice. Here's what one of the comments to the rule says. Very first comment to that rule. A client is entitled to straightforward advice representing the lawyer's honest assessment. Legal advice often involves unpleasant facts and alternatives that a client may be disinclined to confront. Now, here's a little sort of a throwaway. Sure, in presenting advice, a lawyer may endeavor to sustain a client's morale and may put advice in as acceptable a form as honesty permits, meaning you can temper it, make it acceptable to the client, but only to the extent that honesty permits. It doesn't, the fact that you can sort of make it a little more easy to digest does not relieve you of the obligation to be candid. Indeed, the comment goes on. However, a lawyer should not be deterred from giving candid legal advice by the prospect that the advice will be unpalatable to the client. And sometimes that happens. I've seen it in the complaints I've reviewed where for whatever reason, maybe the lawyer's conflict adverse, maybe the lawyer is intimidated by the client. That happens. Wants to stay on the client's good side to keep getting business. That happens. Isn't quite willing because of those factors to give the advice that the lawyer knows is the right advice and knows should be given, but because of how the client's going to receive it, the lawyer is deterred from giving it or sugarcoats it to an extent not authorized by the comment. And when you think about it, when you do that, you might invoke another rule. Have you so sugarcoated the advice that it's no longer even accurate? Is that competent? Is it honest? I don't know, but think about that. So I guess my point is sort of been a little, I wouldn't say loosey-goosey, but over the years I've suggested, hey, is it a violation not to disabuse clients of unreasonable expectations? Probably not. Now I'm not so sure. Now I'm not so sure. I think that it can be, depending on the degree to which you avoid giving the unpalatable, candid advice that the client doesn't want to hear. In any event, anyway, sorry. Whether it's a violation or not, it's a good way to avoid disciplinary complaints. And then the last point I've tried to make on this, sorry, I lost my train of thought for a second there, which happens all the time. Candid advice, however unpalatable, is what we would expect, right? When we hire somebody to help us through a process that we can't do ourselves. So for example, drop your car off and you mention to your mechanic or whoever works on your car, say you bring it in for an inspection in October or November. Yeah, I know my tires are going to get me through another winter. So don't worry about those. The mechanic takes one look at them and knows, no, these tires are not going to get you through the winter. You're going to be at risk. You would expect that person to tell you that, even if they know you're not going to be happy about the expense of buying new tires. Same with your roof. I know my roof's going to get me a couple more years. I just need you to clean the gutters for me right now. Person gets up there to clean the gutters and realizes this roof is a problem. You need to fix it now. You'd expect them to tell you that, even though you don't want to pay for a new roof. Your doctor. Oh, I'm not too worried about my diet. I know I'm going to be fine. Your doctor knows you're not going to be fine unless you make some changes. You'd want them to tell you, even if you don't want to have to make those changes or hear your doctor tell you that you need to make those changes. Other people tell us things all the time that we don't necessarily want to hear, but are what we pay them to tell us because we don't know ourselves. And that's what your clients are like. They certainly have ideas, whether from the internet, whether from their friend, whether from a relative, about how the system works, but they don't know for certain. And sometimes those ideas are unreasonable. They're unreasonable expectations. And your job is to disabuse the client of those unreasonable expectations. And I think if you do, you will go a long way towards reducing the likelihood that the client will file a disciplinary complaint against you. Because in the end, Will they have gotten what they wanted? No, maybe, probably not. But they will have at least gotten something that's pretty close to what you told them they should expect to get. That, again, may not be happy with the result, but they will not be as inclined to make a complaint against you as they would be if they didn't get something anywhere near to what they expected, something they expected only because you continued to let them unreasonably expect. Disabuse them of those notions. Thanks for listening. Have a great day.